And if you're representing the appellee, don't worry, I'll make sure that that all comes out in the wash. With that, I'll call the first case on this afternoon's docket from Johnson County, case number 127043, Swope Lee's Commercial Real Estate LLC appellee versus Lane Slaten and Clareview LLC appellants. Would the parties please state their appearances?
Your Honor, Greg Goheen appears on behalf of appellants.
Good afternoon, Your Honors. Rob Harkin, with me is Rob Titus for the appellee, Swope Lee's Commercial Real Estate LLC.
Thank you. Mr. Goheen, would you like any rebuttal?
Yes, I would like to reserve 3 minutes for rebuttal.
3 minutes are granted. And with that, you may proceed.
May it please the court. Your Honors, we're here today to address a case that involves a commercial real estate transaction involving my clients who are a individual resident of the state of Kansas who is the sole member of a LLC that's incorporated in the state of Kansas that owns certain real estate property in the state of Kansas. The opposing side in this case is a real estate company or agency out of Florida, which is not licensed in the state of Kansas. And during the years, November 2020 through approximately January, February of 2021, those individuals from the Florida real estate entity were involved in purportedly representing my clients in the real estate transaction and attempts to sell the real estate property here in the state of Kansas. So factually, that's essentially the case in a nutshell. From that situation, the way this has devolved is that there was an initial sales agreement contract or letter agreement contract signed between the parties back in November of 2020. That contract provided within it an arbitration provision, among other things. There was a subsequent contract extension signed in January of 2022. And then ultimately, after that extension was signed in 2022, the entity down from Florida attempted to enter into a brokerage agreement with a Kansas real estate broker. So this was after all the initial contracts had been entered into, after the representation had been in effect for a period of several months. And that Kansas real estate broker is not a party to these proceedings in any way, shape, or form, and haven't been from the beginning. They never filed that brokerage agreement with the Kansas Real Estate Commission as required by statute. And ultimately, the property was sold without paying any commission or without the entity from Florida be involved in the actual sale of the property. Following that, the entity from Florida sought to seek to compel arbitration, arbitrated this dispute with an arbitrator. The arbitrator ended up ruling and finding that they were entitled to commissions. They sought to seek enforcement of that award in the state of Kansas through the district court. The district court ultimately enforced that award, and we're here on appeal because we feel that that enforcement of the award is improper under the statutory framework. We think the parties don't have standing to be here in the first place. So that's the premise of the arguments that we presented to the court and to the, in fact, to the arbitrator as well. So kind of getting to the chase of the arguments and knowing that you guys have spent considerable time going through the underlying documents and information in this case, there really are two critical statutes that are in play in this case. One is KSA 583038, and the other is 583077. KSA 50-3038 is the statute that deals with the requirement that no action shall be instituted or recovery be had in any court of the state by any person for compensation for any act or service, the performance of which requires a license under this act unless such person was duly licensed under this act, and I think this is the important part or one of the important parts of the statute, at the time of offering to perform any such service or such act or service or procuring any promise or contract for the payment and compensation for any such contemplated act or service. So the statute that allows the courts to have jurisdiction over claims and to enforce judgments, whether they come from an arbitrator or whether they come from some other source, is embedded in this statute, or even to hear or consider claims for compensation by unlicensed real estate brokers in the state of Kansas is all contingent upon this act, which requires the person to have a license at the time the services were offered in the first place, which in this case would have been November of 2020.
Counsel, I don't know that it necessarily furthers or detracts from the argument, but just as a factual matter, when your client entered into a contract or entered into an agreement to have the appellee seek to sell this real estate, was your client aware that they weren't licensed in Kansas?
So those are facts that we didn't really include in the briefing, I don't believe. And part of the reason is because we're focused on the legal issues since there had been an arbitration in this case. What had happened is reflected in the record in front of the arbitrator, and I don't remember if it's specifically detailed in the arbitrator's award, is that my client initially had sought to sell the business entity as a whole, which would have included the real estate property, and had approached an individual in Florida who had assisted in a prior sale of a business, which doesn't require a real estate license. He subsequently decided to sell just the property and not sell it as a business as a whole, and was referred by that gentleman down in Florida to a real estate company in Florida to assist in the sale of the property. So that's how we got to the point where they entered into this letter agreement. So a couple things that come to mind as we look at this statute. Because the statute requires there to be a person who has an actual license from the Kansas Real Estate Commission in order to be able to bring an action in the first place, we think there's a complete lack of standing in this case, and lack therefore of jurisdiction for both the district court and ultimately for this court to enforce the arbitrator's award. There's no mechanism under the statute. The statutes, and we've cited numerous cases from the district court, or not the district court, the Kansas State appellate courts and the Supreme Court, not necessarily dealing specifically with this provision or these provisions, but clearly, if you look at the Thomas case specifically, makes it very clear that the courts don't have jurisdiction to consider claims for commissions by individuals who are not licensed by the commission. And we'll get to this issue on the foreign licensure statute, which is the 583077 in a minute, and I'll talk a little bit that. That statute deals with sharing commissions with unlicensed persons. The unlicensed person in this case would be the Florida entity, but it doesn't speak and never does speak to that entity being able to pursue a claim in the Kansas courts. This is the only statute. 583038 is the only statute that talks about that sort of gatekeeper function of who would have standing to pursue a claim for unpaid commissions.
So why would the statute give the foreign licensee the ability to share a commission if they follow certain procedures, but then not give them a right to, effectuate, or give them a way to effectuate that right by pursuing somebody in Kansas court?
Well, I can't speak to know the exact mind of the legislature, but I would suggest that reading the statute 583077 might give some inclination to the answer. The statute talks about sharing a commission, not getting a commission. And it talks about having a relationship with a Kansas licensed broker. Again, the Kansas licensed broker would have a contractual right and potentially standing to pursue an unpaid commission against somebody who had entered into that contract to include claims on behalf of the shared portion of the commission that would be to the.
But what if, like here, it's the Kansas person that's not sharing the commission? I mean, we've got this foreign license statute that allows them to share in the commission, giving them a right to receive a part of it. But then the way you're interpreting the whole scheme is to say, well, but that right has no meaning because you can't sue the Kansas broker in
Well-
Kansas to recover your right to share in that commission?
In our particular situation, we don't have the claim being brought against the Kansas broker. We have the claim being brought against the individual, the member of the public, whose entire statutory scheme is designed to protect from unlicensed individuals participating in the sale of real estate in the state of Kansas. So we don't exactly have the fact pattern you're suggesting in front of you, where there's a dispute over the commission between the Kansas broker and the entity out of state entity that's not licensed in the state. But I would submit that it's not my role or position to read words into what the statutes say, and the statutes seem to be pretty clear. And again, if you look at Thomas and several of the other Kansas cases, they do talk about strictly construing the licensure statutes and the commission statutes in these cases.
But are we also supposed to construe the statutes, look at them as a whole and construe them not in an absurd way, but in a logical way?
Yes, and I don't think we're looking at the statute in an absurd or illogical way. There are lots of ways that this could have come out where you would have had a situation where, I mean, just take a look at this section of it again. At the time of the offering, we don't have that here. They clearly didn't even have the brokerage agreement in place at the time of the initial offering, where the letter agreement was entered into. They don't have they never obtained a Kansas license. They never submitted it to the state as required by statute.
But do we have evidence in the record showing us that? Because, I mean, it seems to me in the record on appeal, we have part of a brief filed by Swope Lees in the district court that sort of discusses the topic of maybe the non-filing of the broker cooperation agreement. And then we have the arbitrator's decision that calls it a purported failure to file the broker cooperation agreement, but we don't have evidence of that non-filing. Is there evidence? Is there anything that
I
definitively says?
It was never filed. I don't have the record memorized in terms of whether I can point you to a specific place where there was evidence presented that it hadn't been filed. But again, I would submit that the burden of proof in that situation would have been on the brokerage firm out of Florida rather than on my client, because again, and I can't remember which case it was. I can't remember if it was Thomas or one of the other ones that talks about you have to allege and have proved that you had a valid license at the time. So if there's no evidence in the record definitive that it had not been filed, although I believe there was evidence that it had not been filed, the issue would be that would be been on the plaintiffs in the case to have proved or established, in fact, that they had filed it, and that didn't happen. So I don't know if that
isn't part of the evidentiary issue in this case is that this isn't really a case. Like this was a matter, a dispute that went to arbitration. There was an arbitration decision. There's not a traditional appeal process for arbitration awards. Instead, there's this confirmation process that is really just more of a procedural safeguard that converts the arbitration award to a recoverable judgment. So I'm having a hard time seeing. It seems like we're trying to get behind the curtain to something that the arbitration process just doesn't allow us to do, and the Kansas arbitration statutes don't allow us to do.
So that gets really, well, two things. First of all, I still think you've got the subject matter jurisdiction issue, and I think the statutes are pretty clear on that, whether it's coming out of an arbitration or whether it's a direct action filed in district court. But setting that aside for a minute, then you get into this issue of, okay, we've got this arbitration decision. Does this court or does the district court or does the Supreme Court have the ability to set that aside? Of course, the answer is yes. There are cases by the Kansas court system where they've set arbitration awards aside. And we've suggested in this case, there's two bases to do that. One is manifest disregard of clear statutory authority, which we think exists. We also think that it potentially calls for the commission of a crime, or at least alludes to the commission of a crime if this award is supported and we're ordered to pay out. We don't have a direct Kansas case on this, but we did cite cases from both California and Wisconsin that have very similar fact patterns, where the courts in those situations looked at it and said, you can't avoid the fact that the Kansas law precludes or forecloses a non-licensed broker or non-licensed real estate agent from obtaining or recovering a commission in Kansas for the sale of a Kansas piece of property by going through the arbitration process. And both of those cases essentially concluded that the contracts themselves, because they included that provision, allowed that process to go forward, that those contracts were essentially illegal contracts. So in this case, the letter of agreement entered into would have been an illegal contract because it was entered into without a brokerage agreement that had fully satisfied the statutory requirements. And because it's illegal, it's a void contract, and therefore the arbitration itself can be set aside. And that's essentially what both the case from Wisconsin and the case from California held in that regard. Pardon me. Now, although we don't have cases that are specific to the statute dealing with the licensure issue, we certainly have had at least one other case that has been involved in Kansas where we have had a contract set aside or an arbitration award set aside. And we think that that's the proper thing to do in this case, is that the arbitration award should be set aside, vacated, along with the entry of the award based upon that arbitration decision. So I think that the critical piece of this from our perspective is that, we have a situation where we have a statutory scheme that clearly effectuates and deals with public policy to protect Kansas citizens, Kansas companies from unlicensed representation by foreign real estate brokers. No different than if you have a statute for attorneys where you have to have a pro hoc vici to be able to come in and present evidence and be able to be paid for those services.
And isn't that a different situation than we have here? I mean, there was some involvement with a Kansas broker. I mean, they worked together. It wasn't like your client was the victim of only a foreign broker coming in, correct? You said at the beginning that it was the Kansas broker that was involved mostly with the sale. I think it was just the foreign broker that helped find the buyer.
No. Well, ultimately there was a Kansas broker that did consummate and assist with the sale. That was not the broker that was signed with the brokerage agreement with the appellee in this case. So that was not the same broker. That broker never had a contractual relationship with my client.
But my point is they're dealing with Kansas brokers. I mean, how is your client hurt by the evil that the statute's designed to prevent? I mean, how did the foreign broker come in and take advantage of your client?
Well, in this case, the foreign broker came in and, again, entered into this contract purporting to have a right or essentially a lien on commission sales resulting from the sale of this property, was not involved directly in marketing the property. And ultimately, when the commission went, or the sale went through and commission was paid out to a different brokerage firm, comes in after the fact and is simply trying to take a commission on the sale of the property that they weren't involved in the sale transaction for.
To take part of the commission that your client was obligated to pay, or in addition to the commission to the Kansas?
They're not seeking to take part of the commission that was paid out to the Kansas broker. They're trying to seek, and they were awarded a full commission based upon the sales agreement that had nothing to do with the Kansas broker.
But your client was aware of that agreement when they entered into the sale?
I guess I'm not sure I understand the question. So
was your client aware of the commission sharing agreement and the obligation to pay commission to the foreign broker when they entered the sale?
There was, I guess I want to make sure that the Kansas broker that had the brokerage agreement that was signed with the appellee in this case was not the broker that ended up selling the property. So I'm not sure I understand the question, and maybe I'm just misunderstanding. So he was aware of the letter sales agreement. He was aware of the amendment to the sales agreement. I believe he was aware that there had been a brokerage agreement signed or executed not filed with the state as required by the statute. Again, that's a shall in that statute. So we think that's mandatory. But that's not the broker that was involved in the ultimate sale of the property.
No, I understand that. I'm talking about your client's awareness
Yes.
of these agreements going into the sale. And you just said they were aware, but they just didn't know that they hadn't been filed with the Kansas Commission.
I think that's accurate. I think that's accurate.
Council, this conversation has gone on a little bit longer than we had anticipated, but that's because we've had a lot of questions. And so I'll make sure that you still have your 3 minutes.
Thank you very much. I appreciate it.
You'll get that same courtesy, Council, if we have a lot of questions for you.
No problem, Your Honor. May it please the court. I do want to address just a few of the facts that were initially raised by the appellant's counsel. The parties, the appellant and appellees, they had an initial brokerage agreement under which Swope Lease, the appellee, was going to seek out and try to find somebody to buy appellant property. That expired in January of 2021. So then the parties said, and at that point in time, unfortunately, you don't have a record on appeal because, again, as you said, this isn't from a trial court. The parties said hadn't really done anything under the brokerage agreement because they just were still trying to feel things out, get the property prepared. January 2021, Swope Lease, the appellee, and the appellant came back together and saying, let's renew the brokerage agreement. And they renewed it for a time period of January 22nd, 2021 through April 22nd, 2021. Simultaneously, Swope Lease, the appellee, entered in the brokerage cooperation agreement with Janet Brooks and her real estate firm, authorizing Swope Lease to act as a foreign licensee under Kansas. That contract incorporated all the obligations under 3077. I mean, it's a form contract that the Kansas real estate created and checklist. Basically, you have to do all this, you're qualified, then to act as a foreign licensee. Covered the same exact time period as the renewed contract for the brokerage agreement between the parties here today. And it's that contract that out of which the 6% commission is owed. So when you looked at 3088, they accrued a promise to contract for the payment of compensation at the same time as entering that brokerage cooperation agreement. They met both the requirements of 3038 and 3077 when they did this. I know there's been a lot of issues raised as to whether or not that brokerage cooperation agreement was ever sent to the Kansas Real Estate Commission. Unfortunately, again, you don't have a record on appeal, but as the arbitrators found, he indicated it was a purported failure. And it comes in his footnote. I mean, basically what he's saying is even if they failed to do so, he's not finding that they did fail. He's just saying if they failed, I'm still going to find in favor of the appellant Swope Lease and say it's entitled to its commission. So there was never a finding that they didn't. And so I think it would be incorrect for this court to find, even if you could do it, that there was no, that brokerage cooperation agreement was never sent. There was just never evidence that it wasn't sent. And I believe because it was Mr. Slaten and the appellant argument that he should have to pay, that he, even though he breached the contract, he doesn't have to pay because they never sent it. That's an affirmative defense. That's their burden to present. Certainly their burden to come to you with the record to show that that didn't occur, and they've never done that. So I just want to make those facts are clear. They haven't done it.
Isn't that an important fact to have? I mean, it seems like the arbitrator, it's hard. You don't have a record, right? But it seems as though the arbitrator, based on what you're saying, essentially said, I don't need to find whether this was filed. But isn't that important?
Well, two things to that. That's not what he found. There was disputed evidence of whether or not it was presented. He said it was, they said it wasn't. Arbitrator said, look, they met the claim, and they say, look, even if they didn't, so in my mind, he's saying, well, they did, but even if they didn't, I'm still going to find in favor of the appellant because all the requirements of 3077 subsection B that goes this is how you have to, this is all the requirements you have to be a foreign licensee. They met that. I mean, that's never been disputed in this case. They met subsection B. It's all about subsection C, but that itself, separate and apart from subsection B, tells you to be a foreign licensee, qualified and have the right to receive the commission, isn't dependent or predicated upon it actually going to the Kansas Real Estate Commission.
What's the purpose of sending, of that requirement in C to send the agreement to the commission?
I searched the legislative history to try to make that determination. I haven't found anything, so I can only give my opinion, but it's to allow somebody to come and say, hey, do you have a copy of that record to confirm? It's like, if I, like borrow his Pro Hoc Vichet, and I contact the Missouri Bar to see if that person's is licensed. It doesn't change the fact that he is, an attorney is licensed. It's just whether or not the bar has the documentation to show that that is in fact true, should another court want to find that out.
Kind of like in the Consumer Protection Act, there's a requirement that when you file the lawsuit, you have to send a copy to the Attorney General. But
Exactly.
there's nothing else. The Attorney General doesn't
Yeah,
have
they
any
just
requirements
okay,
to do
thank you.
anything with it.
Yeah.
Just a repository of information.
Exactly. And so that kind of gets us to the heart of the matter here. I mean, we had an arbitration agreement. The appellant or appellants knew what it was. They agreed to it. All these facts that we've been going through for 20 minutes was litigated in arbitration. The arbitrator made a decision. The appellants don't like it, but they don't get to come before you to re-argue that factual evidence and legal consequences. That was all raised during the arbitration. They don't get a second bite at the apple. That's what the Moreland case is all about. I know we gave you a lot of briefing, a lot of case law to review, but that's what it really comes down to. They don't get a second bite at the apple to make this argument.
What findings are necessary for the district court to make in confirming the arbitration award?
Well, it depends on if you go under the statute that outlines what has to be found. KSA 445 has its list of this is when the court can disregard or not confirm the arbitration award. You have to show the fraud and everything like that. And then if you don't find those statutory things, then the question is, well, is there a manifest disregard of the law? Well, here, the arbitrator considered the law. He didn't disregard it. He said, look, I am considering the law on whether or not they are a foreign licensee, whether or not they met the requirements, and whether or not under Kansas law, they are allowed to receive that commission. So he didn't disregard it. He didn't ignore it. He applied what his interpretation of it was. And because that's what he did under the Moreland, district court said, look, he applied his law, his interpretation of law under the Moreland standard of manifest disregard and everything else that goes into it. Court considered it. And even if you as your appellant sit up there, you get cold shivers as to that finding, you still have to uphold the arbitrator's decision. You have to find something where you just said, I'm not even going to consider it. If it was undisputed that we never entered to that cooperation brokerage agreement, if it was just, hey, we're a Florida attorney or a Florida real estate commission, we're realtors, we never saw that cooperation brokerage agreement. And at that point in time, the arbitrator said, hey, I don't care. You didn't do that. I don't care about the law. I'm going to go ahead and award you because I think you are entitled to it. Then he has that manifest disregard as to what the law is because he's not considering what the statutory language of 307.
What if an arbitrator, and I'm not saying that this is what happened here, but what if an arbitrator quotes the statute and then so there's not a disregard for the law, quotes the statute, but then essentially applies it in an inverse direction, right? So leads to an outcome that is absolutely not covered by the statute or is in opposition to what the statute requires. So in other words, the arbitrator has observed the statute, has acknowledged that it exists, has acknowledged that it's binding, and then just has come to a conclusion that is in opposite of what the statute requires. Is that manifest disregard?
I think you have to kind of look at the nuance because in doing so, is he considering the facts of the case? And so kind of coming back to our case, he considered the facts of whether or not we met the requirements of 3077. So he didn't do what you were proposing. And a hypothetical situation, if he looks at the statute and says, okay, I'm looking at the facts are clear, obvious, almost like a summary judgment, like there's no facts in dispute. And despite having all these facts in order, the statute says if you have all these facts in order, outcome X is supposed to happen. And then he says, but you know what? It doesn't matter. I'm going to go with outcome Y. Then you might be starting to get into that threshold of crossing that threshold into the manifest disregard.
Even if let's say that it's not a who cares, right? So the kind of the face that you just had, but instead just outcome X is required, and nevertheless makes the erroneous conclusion that outcome Y is.
If you go back to what Moreland says, then that is not enough. That's not enough to set aside the arbitration award. You still have to confirm. We've quoted that in many ways from different cases. Again, it's the cold shivers. Even if you think, I mean, we want to quote the law because the judges before me are a lot better at that than I am. Even his erroneous view of the law would be binding where the parties have agreed to accept his view of the law. That's one of the cases we cite in our briefing. So under your scenario, if statutory authority has it and he has an erroneous view of that law, it's not, he doesn't care, he has an erroneous view, the parties are still bound by that decision. And that's what the Kansas case law says. And so under your scenario, even that's not what I think happened here, the appellants would still be bound by that decision.
And that's the consequence of entering into an arbitration agreement.
Exactly. And so, I mean, coming back to my outline as I was arguing, I think you touched on it, under the Hodges decision, 317 Kansas 535, an arbitration proceeding is of limited scope. The confirmation process establishes an enforceable judgment and does not constitute an independent judicial proceeding. Under the Evans decision, 230 Can 298, Kansas Supreme Court said, where an arbitration award made under the Uniform Arbitration Act and filed for judgment is attacked by one of the parties, it is not the function of the court to hear the case de novo and consider the evidence presented to the arbitrators.
Your opposing counsel has argued that this decision is not merely an error of law, but rather would result in an illegal conclusion, right? That it would result in an action that is impermissible under Kansas law.
The problem is, to get to that argument, you have to go back to the factual evidence presented to the arbitrator, whether or not they entered this brokerage cooperation agreement with a Kansas realtor. 3077 in clear states they're allowed to do that. It allows them to receive a commission. And even if you disagree with that finding, the decision on the court we talked about a few minutes ago says you're still stuck with it. That's what the arbitrator found, and you have to confirm. So, and I think that's a lot of the problems because we have two orders here in place. You have the confirmation order, and then you have the order under 260 when they filed the post-judgment order saying, well, you should set it aside because it's void. But either way, you still have to come back to the Moreland standard to determine whether or not either one of those opinions or either one of those judgments have to be overturned. You don't get a de novo review. You don't get to review this evidence that we've been talking about today that clearly still remains disputed despite it being actually presented and argued several times at the arbitration proceeding, at the confirmation hearing, at the post-trial motions, and in this appellant brief. You just don't get to come back to do that. Moreland clearly controls.
Counsel, before you leave, how would you distinguish the Mid-Continent Specialist case?
Thank you. That's just where I was going to go. This is an issue of capacity to sue, not standing. That's what our argument has always been. It's a checkpoint. You're a foreign land, you are claiming you have a commission. Because of action, the harm suffered by the appellee was a breach of contract. It wasn't their cause of action to sue the appellants did not arise from 3088. It arose because the appellant breached the contract. In Midland, it all came out of the UCC. It was statutory authority whether or not you have a claim. Our claim isn't predicated upon a statute at all. It's predicated upon a breach of contract. And what the 308 is saying, okay, you have a contract. You have a claim that already exists. You have a harm, so therefore you have standing. But we have a checkpoint here. You don't get to come in and pursue that case, that claim up for breach of contract, unless you meet the qualifications under the Kansas Real Estate Commission Act. And in this particular, it's if you're a foreign licensee. Foreign licensee issue and statute came about in 2004, and then it was revised in 2006 under 3077. And I think that's an important distinction because a lot of the cases cited by appellants came well before 3077 was enacted. And I think even those foreign cases that they cite also don't have the equivalent of 3077. So I think the important distinction is appellee suffered a harm. There's no question of that. They sought to enforce or recover under that harm through the breach of contract claim. They established the capacity to pursue that in arbitration because they were a foreign licensee. And that's the distinction with Midland. There wasn't that case involved conversion and whether or not under the UCC, there was even a property right, but all those issues simply don't appear in this case.
Other questions?
Out of time.
Yep. All right.
Thank you, Your Honor.
Thank you. Council, you have 3 minutes for rebuttal, and I'd like you to start with discussing the difference between capacity and standing and whether there is one under Mid-Continent.
I could do that, Your Honor. Could I make one comment before I do that?
Yes.
I had mentioned that I thought there was a case that was cited in our brief that spoke to the burden and who has the burden of establishing that they are licensed and authorized, and this perhaps feeds into the capacity standing issue anyway. And that is the Marcotti Realty and Auction Inc. versus Schumacher case, where in the Supreme Court of Kansas held that a person claiming to be a real estate broker cannot bring or maintain an action in Kansas courts without alleging and proving he's duly licensed real estate broker at the time of the alleged cause of action arose. So I think that squarely puts the burden of proof on this whole issue of whether or not they completed all the requirements of the Foreign Licensure Act, which I don't even think the Foreign Licensure Act qualifies them as a licensed broker for purposes of the standing to sue, but it at least puts that burden upon them. And I don't think that the evidence was really in that much dispute. I don't think there was any disagreement that they had not filed with the Real Estate Commission office. As to your question, it relates to capacity versus standing. So they are doctrines that sometimes get conflated. I can't remember which justice when I was arguing last, the Kansas Supreme Court engaged. I think it was, I can't remember who it was now, but there was quite a discussion in the context of what's the difference between a capacity argument versus a standing argument. When does an individual have standing to pursue a claim? I think that in this case, the statute is very clear, and we cited one case, and I can't remember which one it is, that talks about there's a statutory component to standing. It's not just I've been injured and therefore I've got, like if you think of 1983 litigation, I've got Article 3 standing because I have a type of injury that would support a claim. That's one aspect of standing. Another part of standing is as a party bringing a lawsuit forward, being entitled to come into court, I have to meet the criteria under the statute to do this. And I think that is precisely what the legislature did with 583038. And I think that the case law supports that, continuing to talk about whether or not somebody who doesn't have that license has the ability to come forward and use the Kansas judicial system to attempt to obtain a commission or to obtain compensation for providing services that they are not legally entitled to provide in the state of Kansas. So I think it is a standing argument. I understand the capacity component of it, but I think in this case, because the statute prescribes specifically saying no action shall be instituted, that strikes me as a standing argument and not a capacity argument. So that's the distinction I would draw there.
And we don't really have authority though that is post the enactment of section 3077, right? I mean, everything is really talking about that licensure in as to 3038, right?
That's correct.
Yeah.
Yeah, that's the way I view it. That from my perspective, the licensure issue, I mean, the standing issue is all premised on 583038. And I don't think that the 583077 salvages that because it doesn't make the out-of-state person a licensed entity under Kansas law. So I think the standing argument stands solely on the 583038 would be my thought on the matter.
Council, at this point, we're past that 3 minutes, but I'll give you half a minute to wrap up.
I will not take up any more of the court's time. I do appreciate the offer and do thank you guys for your careful consideration in this matter. Appreciate it.
Thank you very much. I thank all the parties for their time and for their excellent writing and oral argument today. The court will take the matter under advisement.